Okay, so welcome again to today's webinar, Pitfalls and Challenges with Self-Made Wills. My name's Carly Hanson. I'm the Sector Development Officer at Community Legal Centres Queensland, and we've got some special guests from New Way Lawyers here today, Carolyn DeVries, the CEO, and Jennifer Claridge, the Managing Lawyer. So before we get cracking, I'd firstly like to acknowledge the traditional owners of the land on which we're holding this webinar. Today today we're in Brisbane, and the people here are the Turrbal and the Yagara peoples. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout Queensland and potentially around the country, I'd also like to pay my respects to the traditional owners of the land throughout Australia and welcome any First Australians listening today. So the DIY revolution has resulted in the emergence of some pretty unconventional estate planning methods that you may have come across yourselves. These can range from self-made will kits that you can pick up at the post office, to wills written on the back of receipts, and even a recent case of an unsent text message on a person's mobile phone. So New Way encounters many interesting and challenging examples in their wills and estates team, with many community legal centres sharing this experience. So in today's webinar, Carolyn and Jennifer will share some of their case studies and discuss the legal issues that can arise with these kinds of wills, such as attempting to obtain probate and the additional burden and cost to executors and beneficiaries. So I've sent out the PowerPoints for today's presentation this morning for those who registered. For the latecomers or people that maybe have not seen that email, you can pick up the PowerPoints in the handout section of the GoToWebinar control panel. We're also going to have 2 polls today, so please make sure you note your answers when those polls come up on the screen so we can use those to help run the webinar. We'll take questions at the end of the session as per usual, but if you do have any questions or think of any comments throughout the presentation, feel free to type those into the question box and we'll get to those at the end. We'll read them out for everyone to hear, and Carolyn and Jennifer will do their best to provide you with some responses for those. Today's webinar is being recorded, and we'll put the webinar up on our website this afternoon and send out the link together with the materials for you. So I think without further ado, I might hand over to our fantastic presenters to get started. Thanks, Carolyn and Jennifer.
Thanks, Carly. Good morning, everyone. Great day for a webinar. It's kind of like watching a movie on a rainy day, but instead of a movie, we'll make it a webinar. So as Carly said, we're going to be focusing on the pitfalls and challenges of homemade wills or self-made wills. And we're seeing this more and more often. A couple of situations where we're seeing this in particular is in the case of deathbed wills, where people are faced with significant health situations and maybe they haven't had time to update their will formally, and they get into a situation where they do a homemade will. Also, we often see it where people take the view that the assets that they own are quite modest and that it's not worth going to a lawyer because they have a small estate. So those are 2 of the particular situations where we're seeing some of an increase in self-made wills. And it comes out of a perception where people tend to think that either making a will is straightforward and simple and they can do it themselves, or that engaging a lawyer would be too expensive. What we're going to do in this webinar for you is cover 3 case studies where individuals held one or both of these perceptions and they therefore made a do-it-yourself will. In these 3 case studies that we're going to go through, none of the wills met the requirements to be automatically recognised as a formal or valid will, and it was therefore necessary to make an application to the court to try to have the will recognised as being valid. Now, the end outcome of that is that the application to the court ended up being at a much higher cost than what it would have been if they had have just gone and gotten a professional will done rather than making a do-it-yourself or homemade will. So we're going to move to our case studies. The first case study I'm going to hand over to Jennifer to present, so we'll start on that now.
Good morning. This case study was an application that was made by Capalaba office. The background is about to appear. There it is. As you will see, the deceased had 2 children from her first marriage. She subsequently divorced her first husband, then remarried her second husband. There were no children from her second husband, but as it says, there were 2 children from the first. In March 2016, the deceased was scheduled to have surgery after being diagnosed with cancer. In the lead up to the surgery, the deceased decided to make a will and typed a will on her home computer and printed it and signed it in front of her second husband. And our memory of conversations with the second husband was that she just handed it to him and said, "This is my will." They didn't raise any concerns or have any discussions about witnessing at the time from memory. While the will was made prior to surgery, there was no fear, to the best of my recollection, that there was an expectation that she would not survive the surgery. She did, in fact, survive the surgery and unfortunately passed away in July later, a couple of 3 or 4 months after the surgery. The husband came to New Way Lawyers to engage us to make an application for in relation to the will that she had drafted at home. And the next slide shows you the typed version of the purported will, and you will see that it was simply signed on a particular date. Just looking at that will, can you just consider what might have been done right with this homemade will? And if you would like to comment, it's possible to comment, and Carly will show me where that is. So if you'd like to just give it some thought, send in some comments after viewing the purported will and let us know what you think was done right with this will.
So everyone, you can type your comments, if you have any, into the chat box on your GoToWebinar control panel. It'd be great if you could put your thoughts in, and we'll then be able to have a look at those and see what you think. Okay, so we've got a couple of comments coming through here. So Keith, thanks for typing in. So here Keith's mentioned that the testatrix bequeathed her estate and appointed an executor. So another comment from Sue mentions that she gives away all of her estate. Susan's noted that she disposed of all of her assets and signed the document, and also that the will appoints an executor. So thanks for those comments, guys. That's great.
Thank you. The next slide.
Oh, and it's dated, of course. That's a really good one.
Yes.
All right, so we'll just go to the next slide there.
There you can see each one of those listed. The deceased included her address by way of identification. The purported will included a date, which was already mentioned, and that she gave clear and effective distribution of her estate, which has already been mentioned. She appointed an executor, and it was signed and dated. But as you can see, there were things that were done wrong with the will. So would you like to comment again and give us some feedback as to what you believe was done wrong or had been left out of the will, and send your comments?
So we'll just wait for those comments to come in, but feel free to type them in and put your thoughts in the comment box. Okay, so they're starting to come through, which is great. So obviously some things that were wrong with this will were that it was not witnessed. It wasn't executed in accordance with the Succession Act. The witness was witness signing issues there. Didn't seem to have a revocation clause, and someone's also mentioned that there were no witnesses or was not witnessed. Thanks, guys. That's great.
Thank you. They are in fact, the next slide does actually list the two issues. There was no attestation clause, and the will was not witnessed. But you will notice that the will maker had not previously made a will, and while there was no revocation clause, because there was no pre-existing will, it probably would not have been a determining factor, the fact that there was no revocation clause because there was no previous will. However, we, of course, would always revoke all former wills in any wills that we draft, regardless of whether or not there had been a previous will, because better to be safe than sorry, because this is unfortunately what happens with these wills, is that the survivors are the ones that end up having to bear the burden of an incorrectly drafted will. If you would like to have it, then look at the next slide. We've listed the competing outcomes with the purported will and what might have happened if the will had been declared or was considered to be valid, that the deceased, the husband of the deceased would inherit the estate according to the terms of the will. But if the will was later declared to be invalid, then effectively the wife dies, the will maker dies intestate, especially given there was no other previous will that they could rely on, and the deceased dies intestate, and the Succession Act determines the distribution of the estate, and which is that the first $150,000 in household chattels go to the spouse, and a third of the rest and residue goes to the surviving two sons. Now, one of the other problems of intestacy, the potential effect would be that if she died intestate, the husband may not be considered to have received adequate distribution of the estate. There could have been a subsequent family provisions application. So there's other consequences, but there are a lot of potential problems and ongoing effects that come from people not drafting their will correctly. Okay. So we've got a poll that Carly will explain.
So just launching the poll now. So very shortly you'll see the poll come up on your screens, hopefully. So, okay, looks like the responses are coming in. So we'll give you another 20 or 30 seconds just so that everyone has a chance to vote. So just for clarity, I'll read out the poll if you need some assistance with that. So the question is, was the purported will made 21 March 2016 held to be the valid will of the deceased, or was the deceased's estate administered per intestacy? So there's two options there. Option A is the will made 21 March was held to be valid, or option B, the estate was administered as per intestacy. All right, so the votes are coming in. Oh, it's neck and neck, which is really interesting. Yeah. I'll give you a little bit more time because it looks like about 60% of our attendees have voted so far. And shortly I will close that poll. So I'm just going to close it now.
Seems like people don't have much confidence in our skill and ability, Carly, to get this will through.
So the outcome of the poll, thanks for voting everyone, was that 52% said A, the will was valid, and 48% said it was not valid. Okay, I'll hand back over to the presenters.
Thank you. The purported will made on the 21st of March was actually ordered to be a valid will. And you will see that the process that was followed to obtain an order that the purported will was valid was to file a notice of intention, to advertise a notice of intention and to forward that notice to the public trustee, to complete the application for probate with the affidavit of the applicant accompanying that application, which, as you can see, includes an application, a certificate of death, a copy of the marriage certificate, and a copy of the driver's licence of the deceased. The affidavit also included a lengthy description of the circumstances surrounding the making of the purported will and the reasons that the purported will was not witnessed. We also completed an affidavit of publication and service, which is part of the usual procedure for an application for probate.
Just one thing to add there, people might be wondering why the Exhibit D, a copy of the driver's licence of the deceased, was included, because that's not necessarily a normal document that's included to the affidavit. What that does is it provides prima facie evidence that the signature that is on the will of the deceased matches the signature of the deceased. So that's the reason for that particular exhibit in this situation.
And that would have been mentioned in the affidavit.
Yes, that's right.
As well. And then the next step was to file, along with the application for probate, a Form 9 interlocutory application pursuant to Section 18(2) of the Succession Act, with an affidavit in support of the application, the notice proposing the application without an oral hearing, the proposed order, which was that the will be declared valid, an affidavit of scripts, which is basically a list of all the documents that were filed, along with written submissions, and those written submissions told the court all the reasons why the order should be made for that the will be declared valid. That included reference to legislation, reference to previous cases. There's some standard cases that are relied on in these applications. I don't know them off the top of my head. However, I'm fairly sure they're referred to.
We've got a couple of them later on that we'll go through with you.
And then after the application was filed, we had to arrange for service of the application and the supporting documents on the deceased's estranged adult sons. Now, there was a problem with that also, because they were estranged from the deceased. We had to actually find them so that we could serve them, and that caused a delay, and it added to the costs, which was unexpected, that we wouldn't actually know where they were. But we did find them, we did serve them. And after service, there was no engagement from the deceased sons, and a further application was made to the court for the matter to be determined on the papers. And fortunately, in this situation, the judge did determine the matter on the papers, and there was no oral hearing required, which again adds to the costs. And the order was made that the typed document dated the 21st of March forms the will of the deceased. At the same time, the court makes a grant of probate with respect of the will dated the 21st of March, and the husband was appointed the executor and then was responsible for the distribution of the estate. The applicant's costs were, as part of the order, the applicant costs were paid from the estate, and he was the sole beneficiary, so it didn't really have much of an effect on him, except that the cost for obtaining normally an application for a probate, the costs including professional fees and disbursements, are around 2,500, but because of the extra work, locating the sons, the extra applications, the cost of that was approximately $10,000. And always, in hindsight, it would have been much more cost effective for the deceased to have engaged the services of a lawyer from between March and July before she passed. And I do recall that they did have discussions about that, but it was not something that they ever attended to because the wife was very unwell. They were not expecting her to pass, and even though they had that typed will, if they had realised the consequences of relying on that will, I am sure that they would have attended to having the wife complete a formal will using the services of all of the available law firms that we all work for that provide an excellent service, no doubt. And the cost of the process could have been much higher had the deceased two adult children chosen to either contest the will or if they had allowed it to go through, they could have then, if it had been determined that it was an invalid will, then they would have received part of the estate as according to the rules of intestacy. And unfortunately, if that had happened, then the husband would then have potentially needed to make an application for family provisions for further provision from the will because the assets within the estate were in the name of the deceased in general and fell into her estate, even though the house that he resided in was a house that they had lived in for many years. And the cost of obtaining or the cost of going through the family provisions application can be up to $100,000. So all for the want of a $300 to $500 will, the potential consequences could have depleted the estate even more significantly than $10,000.
The other thing to note too is you can't quantify it, but the stress that this caused our client, the husband, for a period of a good few months, he was in a very uncertain situation where we had to advise him that yes, we were of the view we could get the will declared to be valid, but we certainly advised him of the risk that it could be declared invalid and that the estate falls to intestacy. And for him, he had to live with that knowledge of the possibility that, maybe he wouldn't have the ability to live in the house that he'd been living in with his wife. So that's something that can't be measured in a monetary figure, the stress that this causes people. So in a lot of ways, even though we know that wills can be contested, they do provide a lot of peace of mind and act in some ways as an insurance policy. We're going to move on to case study 2. So this is another matter that our Capalaba office had. The background to it was that the deceased was divorced and had 4 children and a number of grandchildren. On the 22nd of December 2015, the deceased made a formal and valid will through a lawyer, and the will appointed 2 of the deceased children as executors, and it provided for some specific gifts, including a gift of $10,000 to one daughter. Now, the important thing to note there is that this was the only gift received by this daughter, and you're probably already thinking it possibly gives rise to a family provisions claim by her. In addition to that gift, there was a gift of $5,000 to one grandson. The will then provided for the distribution of the rest and residue of the estate equally between the 3 other children, with the provisions of Section 33N to apply. Despite having that formal and professionally prepared will, on the 19th of May 2016, the deceased prepared a handwritten document on the back of a receipt, not even a fresh sheet of paper, on the back of a receipt that he'd gotten from a shop, purporting to be a new will. In or around May or June 2016, the deceased informed each of his children, including the daughter who had been left out of the previous will. So it seems as though at some point there'd been a reconciliation with that particular daughter, and he informed all 4 children that he'd made a new will. In or around June or July 2016, one of the children, who was an executor and residuary beneficiary of the formal will, found the purported handwritten will of the deceased while cleaning his unit. So this was before he'd passed away. And she actually encouraged him to go to a lawyer to have the will correctly drafted. He didn't do that. Not sure why, but he just chose not to. The deceased then passed away on the 22nd of November 2016. We were engaged on behalf of the executors of the formal will that was made on the 22nd of December 2015. So let's have a look at this gem of a will. We've redacted the information so you can't see who it is. So the black marks are our redactions. Very difficult to read, but just have a look, I guess, at how it's presented. It's handwritten rather than typed. There's a few good things about it that we'll talk about in a minute, and a few other things that aren't so good. But so you can see it more clearly, we'll just go to a typed version. So what the will actually says, it has an address at the top and a date, but it says, "This is my last will and all others to be scrapped." Great legal terminology. "I leave my estate to my 4 children to be divided so each gets a quarter share. 3 of Linda's kids, that is Andrew, Eva and Glenn, to get $1,000 each. Tom, Leanne's son, to get $1,000, and another, there was the full name of the beneficiary in this particular case, to receive $5,000. The rest of my estate, consisting of cash or shares, the house and car, can be divided equally among the 4 kids, Judy, Stephen, Linda, Leanne." Unfortunately, there's also no punctuation at all, so I typed it exactly as it was. "Household things divided, sold, or each can select what they want as long as things are divided equally. To this, my last will, I put my signature," and then there's a date, a time, and a signature. So, yeah, good little will. Yeah, so let's go through this now. Same as what we did last time. We're just going to ask for some comments about what do you think was done right with this will. So if you'd like to send through those comments.
So again, guys, just put your comments, if you have some, into the chat box on the GoToWebinar control panel, and we can read those out. Okay, fantastic. So there was a revocation clause. It was signed, dated. It bequeathed the estate. Gives away all of the estate. That seems like all of the good things.
Great.
Yeah, thanks, guys.
It's actually a gem of a revocation clause. I'm going to add it to my precedent bank. So let's just go through a quick summary of that. You've pretty much identified them all. Included his address by way of identification. It included a date. He actually went a further extent and actually included the time. Included a revocation clause. It contained a clear and effective distribution clause. I've qualified that to say reasonably clear and effective. Some punctuation would have helped and different structuring, but I think people can get the gist of what he wanted to do. Despite the fact that there, was a few things that could have been done better, it seemed to have some good knowledge to actually put an attestation clause in there. So I was actually quite surprised by that, and it was signed. So. The next step, just really quickly, if you'd like to provide your comments about what was wrong with the will.
So again, everyone, just pop your comments into the chat box on GoToWebinar control panel, and we'll read those out. Okay, so they're coming through now, which is great. Obviously, there were no witnesses. There was no executor appointed. Not witnessed. Fantastic. Everyone's cottoned on to that one. Did the testator actually put his own name?
Not at the start of the will, but at the bottom, that's one of the... No, actually, you're right. We've got an address and we've got a signature. Yeah, but there was no actual specific name where we usually say, this is the last will and testament of me, and you put your name and your occupation. So, yeah, good pick up.
And just one final comment, not executed in accordance with Section 10 of the Succession Act.
Great.
Thanks, everyone.
Excellent. So you picked that up, the two biggies, and it is a biggie. There was no appointment of an executor, which in a minute you'll see is going to change the pathway that we had to go down. Instead of making an application for probate, we actually have to look at application for letters of administration with the will, and obviously it wasn't witnessed. So looking at the competing outcomes, if this purported will was valid, there were specific gifts to the grandchildren, some fairly small monetary gifts, and then the rest and residue would be divided equally between the 4 children. However, if that purported will was not valid and it was going to be a case of the previous formal professional will being valid, there were again some specific gifts to some grandchildren, but the big difference was that one daughter was going to receive a gift of $10,000 compared to a quarter share of the rest and residue. So fairly significant consequences for this one particular daughter as beneficiary. We're just going to move to another participant poll. We'll see if you have any greater confidence in the skills of us as lawyers after the last one. So this particular poll says, which will was upheld by the court as being the valid will of the deceased? Was it the formal professional will made on the 22nd of December 2015, or was it the purported will made the 19th of May 2016?
So we've got some votes coming in, and we'll give you another 20 or so seconds to finalise your vote. A little bit less even than the last one so far. Just give you another 10 seconds to put your votes in. All right, so I'm going to close up the poll now, everyone. Looks like B is the winner here. So we've got 25% voting for the will made 22 December 2015 and 75% voting for the will made 19 May 2016.
Okay, so it was a case that the purported will made 19 May 2016 was ordered as being the valid will. So I'll take you through the process that came about. It is quite interesting because largely, I guess, the outcome didn't necessarily, although you'll see in a minute it went before the court, it wasn't necessarily the determination of the judge as such, but probably more determined by the fact that you'll see as we go through, there was agreement at some point by the beneficiaries to look at following the purported will, and that was obviously a fairly significant factor in the will being determined to be valid. So let's have a look at this. The matter started the way all good estate law administration matters start, of a notice of intention of claim being received. So the child who was to receive the specific gift only under the formal will dated 22 December 2015 at the very outset provides notice of intention to lodge a caveat against any application for probate with respect to the formal will, or alternatively to make a family provisions claim against the estate if the formal will is propounded. So obviously I've simplified this process. It's a file that has about 5 or 6 volumes. It was, despite the fact that agreement was reached at step 2 here to follow the testamentary intentions in the purported will dated 19 May 2016, there was actually a lot of acrimony. 3 children were got along quite well. However, the child who had been left out of the will was quite put out, quite antagonistic, and there was allegations of mental health issues, which, based on some of the things we saw, may have been founded. So step 2 that agreement was actually reached to follow this purported will. The big issue, and this is really bizarre, is actually that the parties struggled to reach agreement about who would be the administrators of the estate. So Because in this purported will the deceased did not name an executor, each of the children have standing to make an application on this purported will as applicants. And they all wanted to do that. However, the 3 children that were beneficiaries of the formal will actually didn't have a lot of trust in the daughter who'd been left out of the will and didn't agree to her being an applicant. In the end, there was agreement eventually reached after a lot of dispute that the 2 eldest children who were the named executors in the formal will should be the applicants. And one of the main reasons for that is that they were the parties that actually were in possession of the purported will. So after agreement was reached, a Form 103 Notice of Intention to Apply for a Grant was advertised and sent to the public trustee. We then had another red herring where there was a dispute about the assets of the estate, including a camper van that was allegedly sold by the child left out of the formal will, dated 22 December 2015, when she was actually an attorney for the deceased. So I'm wondering whether that's what kind of led to a lot of the issues and, originally her being cut out of the will. But, yeah, that took up a little bit of time to sort out. The next step was then that affidavits were sought from each of the beneficiaries under the formal will and from each of the beneficiaries under the purported will, showing that they consented to follow the testamentary intentions in the purported will dated 19 May 2016. So the strategy behind that was that if we could show the court that everyone was in agreement, it was more likely that this will would be declared to be valid. So we sought affidavits from all of these people. We then filed an application for letters of administration with the will with the normal forms that you do, the application, the affidavit, and the affidavit from the applicants, and the affidavit of publication and service. At the same time, we filed an interlocutory application pursuant to Section 18 of the Succession Act. We filed the application, we filed the affidavit in support, we filed a notice proposing an application without the oral hearing, we filed an order, we filed the affidavit of scripts which attached the purported will, we did written submissions, and then importantly, as I mentioned, we actually filed affidavits from each of the beneficiaries under the formal will and the purported will, except for 3 beneficiaries. So we actually got, I think in the end there was about 8 or 9 beneficiaries, maybe more.
Lots.
Yeah, maybe even 11. And we actually got affidavits from all of them bar 3, one of them being the daughter who'd been left out.
She actually only provided that affidavit in the last week,
Yeah.
I think, before the final hearing.
We'll get to that. So at this point when we filed, she didn't provide an affidavit consenting, although she had actually agreed to it, and it benefited to her. I don't know what she was thinking, because, she should have agreed to it, because if it went per the previous will, she actually only got $10,000, so it was in her interest to agree. Given that we had 3 beneficiaries that wouldn't sign the affidavits, we then had to serve the application and supporting documents on all the interested parties, and at that point the matter was listed for oral hearing. After the matter was listed for oral hearing, but before it was actually heard, lo and behold, the 3 remaining beneficiaries who hadn't provided the affidavits after being served provided them. Had they have provided them earlier, we may have actually been able to have the matter heard on the papers rather than an oral hearing, which would have reduced costs. So a bit of a shame that happened. But ultimately, you'll see at point 11, we were successful in getting an order that the purported testamentary document of the deceased made the 19th of May 2016 should be recognised as the will of the deceased. There was a grant of letters of administration to the applicants, and costs were paid out of the deceased estate on an indemnity basis to the applicants, but not to the daughter who was privately represented. I'll just go through very briefly, because we are running short on time, the key legislation, case law and evidence that supported this case study outcome and the case study outcome of case study 1. So the section of legislation that we're dealing with is section 18. The key part of that is section 18.2, which says that the document or the part forms a will, an alteration of a will, or a full or partial revocation of a will of the deceased person, if the court is satisfied that the person intended the document or part to form the person's will, an alteration to the person's will, or a full or partial revocation of the person's will. I personally think that's the worstly worded piece of legislation I've read. But basically what it's saying is that as long as you can show that it was the deceased's intention that a particular document was to form part, was to be their will or an alteration or revocation of the will, that's the key factor. And in making a decision under subsection 2, the court, in addition to considering the document or part of the document itself, can have regard to any evidence relating to the way in which the document or part was executed and any evidence of the person's testamentary intentions, including evidence of statements made by the person. So those are the two key pieces of legislation. And the principles concerning the operation of that section of the Succession Act have most recently been put together by Justice Brown in re Nicol and Nicol and another. Given the time constraints, I'm not going to run through all of that. I'm going to leave you to read that in your own time about how the case law talks through how these can actually be applied. So we'll skip over these next few slides, and as I said, you can read those in your own time. But basically, in this case study that we've just looked at, case study 2, the key factors that were submitted as supporting the decision that the will should be declared valid was the following: that the will constituted a document within the meaning of Section 5 of the Succession Act. Notably, it was a handwritten document by the deceased on a piece of paper, and it therefore met that definition. The will purported to state the deceased's intentions about what was to be done with his property upon his death, and that was apparent from the fact that there was several gift clauses. There was a residuary disposition of his estate, the fact that the document said "my last will" on 2 occasions, and the fact that the deceased signed the will next to the words "to this my last will I put my signature," which is really an attestation clause. So the submission was that it was intended by the deceased to be his will. It represented how he wished his property to be distributed upon his death. Again, I'll let you read through the last bit of those submissions on your own. I will just take you through paragraph 5. It talked about that the court also had to be satisfied that the deceased had testamentary capacity at the time he made the will. And in the lead up to the making of the will, the deceased and the applicants had daily interactions, and in those interactions, the deceased was able to recall past events without fault and was able to note any pending or upcoming future events easily. When the deceased was admitted to hospital in September and October, he was assessed cognitively and passed all those cognitive tests easily, so that was helpful. There was no evidence that suggested that the deceased did not have capacity, and while there was no medical evidence as such, the surrounding circumstances indicate the deceased was able to function and think normally. Looking at some alternative processes that could have played out in this particular case study, it's quite interesting. The first alternative process is that we could have actually made an application for probate on the formal will, dated the 22nd of December 2015. And once that was done, we could have actually done a deed of family arrangement varying the terms of the formal will to reflect the purported will, dated 19 May 2016, and then done a preparation of an indemnity for the executors. This alternative process was one that we did strongly consider at the outset, but due to the behaviour and the conduct of the daughter who had been left out of the will and the level of distrust, it was ultimately decided this wasn't going to work. Every time we tried to present that as a possibility, as possibly being a lower cost option, there was the response of, well, we'll file a family provisions claim. So that was the reason we couldn't go down this pathway, which is probably a shame because I think it would have ended up being a lower cost outcome. I've covered in that alternative process too. That was the other option of, notwithstanding the response, we could have actually filed the application for probate, waited for them to file the family provisions claim in response, and then done a deed of settlement. But again, I think the costs at that point definitely would have ended up higher than the pathway we went down. But that being said, the costs in this matter were largely due to correspondence about who was going to be the applicant in the application for letters of administration, and to do with the asset, the camper van asset.
And it was also, there were so many beneficiaries and we had to prepare so many affidavits that increased the cost considerably.
Exactly. So normally our costs of obtaining letters of administration with the will, and we've done quite a few of them, would be about $3,500, including professional fees and disbursements. This is horrendous. In this matter, the cost of actually having the purported will ordered to be valid and a grant, that should be granted, letters of administration issued, was approximately $17,000. Without a doubt, much more cost effective for the deceased to have done, updated his will at a cost of maybe $300 or $400. The real difficulty with this, the value of the estate in this matter was around about $450,000. So do the maths on that. You're talking almost 5% of the estate went in fees, which is just horrendous.
And just by as interest, the cost of the $17,000, that doesn't include the cost of the barrister that was retained to act at the hearing.
Okay. Our final case study, I'm going to hand back over to Jen for this one. This one's slightly different.
As you will see, the background to this case, the deceased had made a professional will and subsequently made a codicil a couple of years later, and the only reason that the codicil had been made was because there was a spelling error in the original will. And didn't actually change anything to do with the distribution of the estate. The deceased passed away in September 2014, a very long time after the codicil was made. However, when the original will had been located after the deceased had passed, sometime between 1999 and September 2014, the deceased had made some redactions and some handwritten amendments to the original will. And again, they didn't have a significant influence on the distribution of the estate. But the other major problem after the deceased passed was that the original codicil could never be located. All we ever had was a copy of the codicil, and we were engaged to act on behalf of the executors. And the next, you will see the amended will. We've redacted some parts of it.
Just by way of clarification, so our redacted parts for confidentiality are the solid black parts.
Yeah.
You'll see the yellow comments are the amendments that the deceased made.
That's right. And we were able to obtain a copy of the original will that showed what was underneath the big black lines that the willmaker had made to the will. There were on the page 2 of the will, there was also some other changes. Somebody had died and there was a line through it to say that they had died. So there was some, even though there were handwritten amendments, they were not so significant that they would have made much of a difference to the outcome. It was the major problem that we had was the fact that we could not locate the original copy of the codicil, and we had to then deal with that issue. So if you would like to, I don't know that we have enough time actually to.
Yeah,
we'll do. If you'd like to let us know.
Oh.
No?
No, sorry, go ahead.
So the process, we're not yet. The process for obtaining a grant of representation with the will was just the normal process that we follow. And we also obtained, as I said, we obtained a copy of the original will that hadn't been amended, and the person whose name had been completely blacked out, their name appeared in the copy, so we made sure that they signed a renunciation not to act as the executor. And to obtain the grant of representation, we made an application for a grant of probate with the application document, and there was the usual advertising that would have occurred at some point, notice to the public trustee, and we made an application for probate, as I said, with the affidavits. We also made sure that an application an affidavit in relation to plight and condition was completed, and just the usual affidavit of publication of service. Then an interlocutory application, Form 9, this seeking to dispense with the provision of the original codicil, was filed, and an affidavit in support of the application. We also sought to propose that the matter be heard without an oral hearing. We also filed the order and again the written submission that deals with the legislation and the case history. At point 5, it actually states that the hearing was made on the papers. The hearing was actually determined by way of an oral hearing rather than on the papers, but fortunately it was a fairly simple hearing and we didn't retain a barrister, so our clients didn't have to bear the costs for a barrister. And so their costs, as you will see from this next slide, is that they had the usual cost for the obtaining a grant of probate, which is around $2,000, and additional costs were $2,500 in relation to the filing of the application for an application to dispense with the need for the original codicil, and the additional cost was $2,500. And again, it would have been far more cost effective for the deceased to simply make a new will, to leave out anybody he didn't like or anybody that had died.
Okay, finally, just some general tips and pointers for you all. So when you're dealing with any matters that involve self-made wills, the best, I guess, advice we can give from our experience is set your expectations with the client, whether acting for the executor, administrator or beneficiary at the start of the process. The expectations that you need to be setting are that the process for obtaining a grant of representation is going to be more complex than usual, and it may involve court appearances, whereas normally that's not the case. The timeframes for obtaining a grant of representation and administering the estate is going to be longer than usual. The costs are going to be higher than usual, and there's an increased likelihood of family provisions claims. So the initial consult with a client when you're dealing with self-made wills, there's actually no good news. They're not going to walk away particularly happy because really you've got to explain these things. And at that point, I think they start to realise that, well, really it would have been, cheaper and easier had their deceased family member or friend updated their will. Second thing is consider all the possible strategies and processes for resolving the matter at the outset, as often there will be more than one option. You'll see that we talk through some alternative processes on some of these case studies. So you need to be careful to think of those in advance, because sometimes once you go down a pathway, you're actually going to lock off some of those other strategies. So you need to look at the matter holistically at the start and determine what's the best outcome for your client. As I said, in case study, one that was a calculated process of of, saying, look, we think we can get the will determined to be valid, so let's have a go at it, rather than letting it fall to intestacy and do a family provisions claim. And, we did make the right call on that. Because had we gone down the pathway, getting that will validated meant he took everything, whereas had the estate gone to intestacy and he made a family provisions claim, there's no guarantee he would have gotten the entire estate. So thinking through what the best options for your client are and the best pathways for getting there is really important. Another one that Jen actually doesn't sometimes agree with me on, it's good to have professional differences. Sometimes if I'm not sure on a self-made will whether it's likely to be declared to be valid and a grant of representation issued with respect to that will, providing there's no negative consequences for the client. If you think it might get through without doing any of these extra things of an affidavit of plight and condition or an interlocutory application, there's no harm in actually filing a simple application for a grant and then letting the registry issue a requisition notice, because at that point the registry has then defined for you exactly what they want. So rather than overkill, where sometimes you might do all of these applications and it may not have been necessary to go to that extent, I actually think sometimes it's not a bad strategy to, if you're not sure, submit just the normal forms and let the requisition come back, and then you know what you're dealing with. So they're my tips and pointers. Don't know if Jen's got any further ones she'd like to add.
The only tips I would give you in relation to people who do DIY wills is, in community legal centres, we often have the opportunity, when people come to us initially, before they go to lawyers, they might come with a will and ask questions about it, and we get the opportunity to point them in the right direction, but we also get the opportunity in our offices and at the community legal centres to point out that everybody needs a will. This is the consequence. Look at this homemade will. This is where we are. It's much simpler and cheaper just to make your own will. Do it right at the beginning. And also, when people come to community legal centres to get information about separation and divorce, that's an opportunity to tell people you need to make a new will. Quite often they say, well, I don't have one. So it's an opportunity to tell people, make your own will. And I would like to take this opportunity to, if I could take a poll as to how many lawyers actually have their own will, I think you'd probably know that the vast majority of lawyers don't have their own wills, especially the people in my office. And I encourage people to make a will, because, as you can see, these are just 3 case studies. The consequences of not making a will, even when you think you've got nothing in your estate, the consequences are costly, and it's not just the financial cost, it's the emotional toll that it takes on the surviving family. And I've seen that through the volunteering that I've done, but I've also seen it through wives who come in whose husbands have died. There's no will, they've got children, and it just creates such enormous emotional, financial, and takes a personal toll for these survivors. And if you're not going to think about yourself, you need to think about your surviving family.
Definitely.
That's some excellent advice. I probably should get my will updated. So everyone, thanks for listening in today. Our presenters are happy to take questions, so please pop any questions you've got for them into the questions box. And while you're doing that, again, thank you so much for sharing those excellent case studies. It's really good to hear some of the weird and wonderful things that happen out there, and certainly I'm sure that there are community legal centres who are dealing with similar kinds of wills. So we've got a couple of questions coming in now. So one question is, are you able to just briefly explain, for those who aren't sure, what a family provisions claim is and who can make it?
The legislation defines who can make it, but generally a family provisions claim is made when a will doesn't leave adequate provision for a particular class of people. They are spouses, children, stepchildren, adopted children, or any dependent of the deceased. Any of those people, if they're not either if they're left out of the will completely or if they are not provided for adequately in their view, then they can make an application for further provision is the term that's used. And they do that by giving notice to the executors that they are going to make a claim against the estate for further provision. And it's very expensive to the estate. And as I said, it can be up to $100,000, and that comes out of the estate before anybody gets anything.
Thank you for that. Hopefully that answers your question, Keith. So the next question here is, what's your view about will kits?
I'll take this one. So I think it's a hierarchy. We've got self-made wills, which we've talked about, which sit at the lowest level. If you've got no other resources and you can't get a will made any other way, then, do something and do it as a homemade. Next step up would be will kits. Good. But I've also seen people in there, based on what they think's best, make amendments to the template of the will kit, which invalidates it. I've seen probably one of the worst self-made wills I've seen is actually an amended version of a will kit where they crossed out things and it was actually just illegible and I had no idea what they wanted to do. But that's a one-off. Generally, they are better than self-made wills because it at least it forces you to appoint an executor. It has a revocation clause in there. It has an attestation clause. So I think they're better than self-made wills. And then obviously the next level up is a will prepared by a lawyer. So I think that, people should consider them in that order of firstly a professional will. If they can't afford that, then a will kit. And then if they can't afford that, a homemade will.
Thank you. So I've got another question coming through here, just around whether it's necessary to update your will every time you change your address.
No. You'll see when you do the Form 103 Notice of Intention to apply for a grant, there's an opportunity to list the address of the deceased in the will and then the last known address. So you can deal with any changes of address through the actual grant of representation process and the administration process.
And the advice that we give to our clients when they make a will with us is to review their will every couple of years, have a look and see if there's been any significant change to the beneficiary, to their executors, or if there's any significant change that they would like to make to their will. And we encourage people to make a new will if that's the case. The only other, if people have a will and then they marry, then the current will is revoked by marriage, so you need to make a new will. If you have a will and divorce, through legislation, a former spouse is, any gift to them is revoked in the will. But if you find that the former spouse is your only executor, then you need to make a new will. So we always encourage people to review their will every couple of years, make sure everything's up to date, that they like their will. And other than that, there's really no reason. The wills that we try to draft are wills that will see people through potentially any change in circumstance other than marriage and remarriage. Same goes for registered relationships.
All right, that's everything for today. So thank you everyone for tuning in, and on behalf of everyone listening at their desks, wildly clapping and cheering, thank you very much to our presenters from New Way today.
Thank you, Carly.
Yeah,
thank you, everyone.
Thanks.
So I'll have the recording hopefully up on our website later this afternoon, and I will also send out a request for you to provide some feedback. So please do that when it comes through. Thanks so much, and I'll see you next time.